5 seconds to go. Start. Anomalously, although her husband can rape her, but he cannot molest her, for if he does so, he could be punished under the provisions of IPC. This was recognized by LCI in its 172nd report, but was not commented upon. It appears, therefore, that different and irrational standards have been laid down for the treatment of the girl child by her husband, and it is necessary to harmonize the provisions of various statutes and also harmonize different provisions of IPC inter se. In the context of abortion, the right to dignity entails recognizing the competence and authority of every woman to take reproductive decisions, including the decision to terminate the pregnancy. Although human dignity inheres in every individual, it is susceptible to violation by external conditions and treatment imposed by the state. The right of every woman to make reproductive choices without undue interference from the state is central to the idea of human dignity. Deprivation of access to reproductive health care or emotional and physical well being also injures the dignity of women. Where two constructions of a provision are possible, courts ought to prefer the construction which gives effect to the provision rather than rendering the provision imperative. Courts must prefer a construction which is in favor of the constitutionality of the statutory provision. A narrow, strict interpretation of a statutory provision which runs counter to the constitutional mandate should be avoided. It seems to us that to give Rule 3b a restrictive and narrow interpretation would render it perilously close to holding it unconstitutional, for it would deprive unmarried women of the right to access safe and legal abortions between 20 and 24 weeks if they face a change in their material circumstances similar to married women. The Constitution Bench in Express Newspapers Limited versus Union of India gave a wider meaning to Section 9(1) of the Working Journalists Condition of Service and Miscellaneous Provision Act 1955 to avoid rendering it unconstitutional. The Working Journalists Act provides for the relevant criteria for the fixation of the rate of wages. The petitioners in that case argued that the Working Journalists Act imposed unreasonable restrictions on the freedom to carry on business inter alia on the ground that the capacity of the industry to pay was not set out as one of the criteria in the fixation of wages by the Wage Board. This court held that the capacity of the industry to pay was one of the essential circumstances which should be taken into consideration for fixation of rate of wages higher than the bare subsistence or minimum wage. In Geetha Hariharan versus Reserve Bank of India, a three-judge bench of this court had to interpret the term after him in Section 6A of the Hindu Minority and Guardianship Act 1956, which provides that the natural guardian of a Hindu minor in the case of a boy or an unmarried girl is the father and after him the mother. This court interpreted after him to mean in the absence of to further the constitutional mandate of gender equality as enshrined in Article 14 and Article 15 of the Constitution. Stop.